morning. Good morning, everybody. Today we're going to talk about access to your medical records policy and some of the rights under the law in case your company's under an OSHA investigation. So let's start off and let's talk about medical and exposure records policy. OSHA has enacted a standard. It's called Access to Employee and Exposure Medical Records. It's 29 CFR 1910-1020, and it establishes a uniform workplace requirements for the accessibility of such records to employees and their representatives, and to define the responsibility of employers. Now, if it looks like I'm reading you some kind of a law or a code, it's because, when we talk about this, I have to read a few of those to you, just so you understand. So, with that being said, let's talk a little bit about the employees and what their rights are. You have the right to access relevant exposure and medical records, and to know and understand how OSHA's standard covers you in the event that you're assigned or transferred to work that involve toxic substances, if a current or former employee who has or may have been exposed to toxic substance or harmful physical agents is working with you, if you may have been exposed to anything, and also your legal representative has the right to come and see those records also. Designated representatives would be an individual who you designate, which could be a relative or, let's say, an attorney in some cases, if something had happened to you. So what should you be concerned about now that I said that and everybody's, got their ears up in the air? Let me give you some examples. If you're in the construction business, you run into all kinds of metals, dusts, lead, biological things like bacteria, viruses, COVID stuff that's out right now, fungi that might be on the property from water that's been sitting for a long time, or you might have a lot of different physical stress like noise, heat, repetition of motion, things of that nature. And one of the best places, honestly, to go to if you're concerned about stuff is to the safety data sheets, and they're available for all the products that you have there on site. That's one of the places I would recommend that everybody always looks at. Look at the safety data sheets. You'll see if there's any hazards that might be on the job site. So what is access? Just what does that mean? Access means the right to examine and copy medical and exposure records. As an employee, you have the right to access exposure records, medical records, and subsequent analysis based on these records that concern your employment. So here's the rule. An employer must permit employees or their designated representatives to access such records relevant to the employee free of charge and within a reasonable time period. As the employee, that's you, and your designated representative, you may have access to these records in one of three ways. Number one, the employer may give you a copy of the documents. Number two, the employer may provide equipment for you to copy the document. In other words, they might open up the file, say, here's the documents, here's the copier, go ahead and copy them off. Or the employer may loan you the documents to copy someplace else if you so desire. It's wide open. Those documents are your documents also. You have the right to see them, you have the right to read them, and you have the right to have a copy of them. What type of records may be accessed? Well, all different kinds of monitoring results of your workplace. It might be air measurements, could be harmful physical agents that are in the workplace. Most of the time where you're working, you don't see things like this. It might be biological monitoring, Or you might just want to see the safety data sheets once again, containing information about the substances or the different materials that you have on site. You may also access any employee medical records concerning your health status that were created or maintained by a physician, nurse, a healthcare professional, a technician. The employee medical records can include medical and employment questionnaires or histories, results of medical examinations and laboratory tests, medical opinions, diagnoses, progress notes, and recommendations. Let's say if you got hurt on the job, maybe you got a sprain of a muscle or something of that nature. First aid records, descriptions of treatments and prescriptions, and then also employee medical complaints. That's it under access to medical records, the things that you're allowed to do. Just remember, if you want to see your records, you're able to do so, and you will have the ability to make a copy of them and take them with you. Okay. What happens if OSHA shows up on the job? Have you ever been on a job and all of a sudden everything sort of stops? My gosh, OSHA's here. Let's talk about that and what your rights are under the law. Number one, if OSHA shows up, they have jurisdiction over the workplace. They have the right to inspect the workplace for safety and health violations. They have the right to gather information. They can take pictures, video. They can ask to interview people. They have the right to expect truthful responses. If anybody ever asks you a question, always be honest and truthful about it. And they have the right to private interviews, but please remember, it's only with employee consent. The employer has the right to train its managers, supervisors, and employees about their rights. That's what we're doing today. They have the right to representation. They have the right to end the inspection process at any time. And they have the right to interview employees regarding their responses to OSHA questions. They also have the right to require a warrant to conduct the inspection process. But I'll tell you, you shouldn't do that because, guys with guns and warrants do show up when you do that. It's always best to work things out to the best of your ability. Here's the important part, the employees. You have the right to speak with an OSHA representative privately if you so desire. You have the right to representation during all interviews by OSHA. That means you can ask to have somebody there with you, and that's a good thing to do because they're witnesses to what the OSHA inspector asks. And you have the right to decline any conversation or any interaction with an OSHA representative. You can always say, "No, sir, I'm busy today. I do not want to be interviewed." So let's get into it just a little bit more. OSHA's had a long reputation as somewhat of a punitive federal agency that has no compunction in levying fines that often financially can cripple companies for years, or in some cases it can put them out of business entirely. Frankly, from what I have seen in my experience, OSHA doesn't care about the company, and they don't care if you lose your job. I know that's a harsh statement to say. In the last few years, their only concern seems to be, I'm going to fine the company. Now, how much will it be? All too often, these fines have been trumped up charges in the guise of worker safety. I want to give you an example. How about a proposed fine? It was $2,380 for having a bench grinder tool rest 1/16 of an inch out of tolerance, and the grinder wasn't even in operation. No, we're not kidding about that. So let's talk about inspection conduct. I want to make sure that you're safe and that you're guarded. During any inspection, the compliance officer will likely request employee interviews. That can be with management, it can be with non-management. They do this in order to gather facts as to whether there may have been violations of the agency's regulations. Make no mistake, the ultimate purpose of those interviews is nothing other than to gather evidence to support the government's case should this case go to court for one reason or another. If you, the employee, or the company gives inaccurate, incomplete, or confusing responses, those statements are more often than not the basis for civil citations with monetary penalties, or in worse cases, if something really went wrong on a work site, extreme cases of criminal liability. So, many times we refer to what's called the OSHA's Field Operating Manual. Section 8A2 of the Act authorizes OSHA representatives to question an employee privately. So we have to think about that. They have authorization to ask to question privately any employer, owner, operator, agent, or, once again, employee. We're also fully aware of the provisions of the Bill of Rights and well-established case law that puts limitations on this authorization. Remember, OSHA has jurisdiction over the workplace. The OSHA Compliance, Safety, and Health Officer, that's sometimes pronounced COSHO, may or may not have reason to be on the company premises. The scope of the investigation will be determined, which establishes boundaries, both physical and administratively, which the OSHA representative may not cross during the inspection, and that is always done before they walk around the premises at all. OSHA and its COSHO, that's the OSHA representative, have a right to truthful responses to their questions. Always please be truthful. The compliance officer has the right to interview the employee in private only if the employee consents to that interview. Each employee has essentially 3 avenues of choice when asked to be interviewed by a compliance officer. Number 1, you can agree to the interview without any representation whatsoever. Just walk into the office, sit down in private, and you have the right to talk to an OSHA representative. You may agree to the interview, but with only representation there with you. That's another person being with you. That can be an attorney if you want to. It could be Dave Fuller. He could be there. And you know what? If I was going to recommend any person to be there with you, it would be Dave. He knows what he's talking about, and he could keep you out of trouble, and he can act as a witness as to what they are asking of you, what the questions are. Or you can be declined to be interviewed entirely if you want to. You can just say, no, I don't want to talk to you. Do it politely. You know, smile on your face. No, sir, I have work to do. The employee, if they so wish, has a right to a private one-on-one, I'm going to go over them again, one-on-one interview with the COSHO. It's confidential and it's considered a protected activity. You have the right to decline a one-on-one private interview. You have the right for a person of your choice to attend the interview, Dave, and if the compliance officer refuses to allow this person to attend, you have the right to decline to be interviewed. If they say, no, we're not going to let Dave in here, you can say, well, I'm not going to be interviewed then. And just turn around and very politely say, excuse me, and walk away. Again, if the compliance officer refuses to allow this person to attend, you may decline the interview for no stated reason. A simple no will suffice. You don't need to offer any reason for the OSHA rep to the OSHA rep or anyone else. The company highly advises this course of action using the compliance professional's representative, which would be me, but I would defer to Dave. He's your real representative. Once you will have a witness to what you said, let me rephrase that. You will have a witness to what you said and to what you didn't say and to what the question was they asked you. Can I give you an example? We've seen this happen. We have seen the OSHA representative purposely make a mistake on recording information during the interview. When the mistake was corrected by him because they write up a report on the things they believe were said. When a mistake was corrected by that individual on the written report, they would draw a line through the mistake, initial it, and then request the employee also to initial it. Should you do so? You've just affirmed everything the COSHO has written on the entire page without any review on your part. We recommend that you do not sign a statement. Please don't do that unless you're advised of all your rights by a COSHO, unless Dave would give you the nod to go ahead and do it. I would never sign any document that was written by a field COSHO and say, please sign here. Don't do that. You have the right to end the interview anytime for any reason. You have the right to refuse to sign statements and or be tape recorded or videotaped or to be photographed. Again, since the interview is voluntary on your part, you're not required to sign or do any of that. You can simply say no. To reiterate, any person can refuse to have their photograph taken or be recorded or be videotaped because you have the right to say no, I don't want to be interviewed. Another significant issue that might arise is an OSHA inspection after a serious accident involving a fatality or multiple injuries, and there may be some potential criminal liability for you or quite possibly for the employer. A basic right under the United States and the state constitutions is self-incrimination, commonly known as the Fifth Amendment. Please remember this. The OSHA compliance officer is not required to give you, the employee, the Miranda warnings that inform the employee that in the interview you have the right to remain silent. You have statements that you make that can and will be used against you. You have the right to have an attorney, and if you can't afford an attorney, the state will provide one for you. You never hear a COSHA officer say those things because they're not a police officer. But everything you do say can and will or might be held against you or the company itself. The end result may not have to worry about a thing. Might just be an interview and it's not a big deal. Your safest position is to ask for Dave Fuller's presence to protect your interests, or just decline to be interviewed. That will be your choice to make. Now, we had a quiz. Let's go over that real quickly. You have the right to examine and copy your medical and exposure records by which of the following ways? Number one, the employer may give you a copy of the records. Number two, the employer may provide equipment for you to copy the documents. Or number three, the employer may loan you the document to copy off-site. Which one of those is the way that you're allowed to get your records? Well, of course, it's A, B, and C. It's all of them. OSHA, number two, question number two, OSHA has jurisdiction over the workplace. True or false? That's true. Number three, the employee, if asked to do so, must always talk to an OSHA inspector. No, you don't have to talk to anybody. That's false. And number four, the OSHA compliance officer has the right to interview the employee in private only if the employee consents. True or false? That would be true. Only if you consent. Hey everybody, please be safe, okay, on the workplace. Before you stop and do any task or job, would you please think about what you're doing? Make sure that you look around. Take 5 seconds to do that. If you'll do that, you reduce the accident rate by 95%. And we want everybody going home safe. Thanks very much. I'll see you next month. Take care.